I stared at the woman standing on my doorstep, her perfectly manicured hand clutching a stack of papers like they were some kind of holy scripture. And I knew my peaceful Saturday morning was about to turn into a complete disaster. "Mr. Anderson, I'm Patricia Whitmore, the president of the Meadowbrook Estates Homeowners Association," she announced, her voice dripping with the kind of authority that people who have never been told no tend to develop. "We need to discuss the upcoming construction of our community pool." I leaned against the door frame, coffee mug in hand, trying to process why this woman thought showing up unannounced at 8 in the morning was acceptable behavior. Construction of what now? Patricia's smile was the kind that never reached her eyes. "The community pool. It was approved at our last HOA meeting. The most efficient access point runs through your property, specifically along the eastern boundary. We'll need an easement." I blinked. "My property isn't part of your HOA." "Well, technically," she said, flipping through her papers with the efficiency of someone who had rehearsed this conversation a dozen times. "When the development was built 15 years ago, your lot was originally intended to be included. It's really just a formality that needs to be corrected." "A formality," I repeated, taking a long sip of my coffee. "Madam, I bought this property 5 years ago. I specifically chose it because it wasn't part of an HOA. The deed is clear. I'm not part of Meadowbrook Estates." Patricia's expression tightened, the kind of look that said she wasn't used to people disagreeing with her plans. "Mr. Anderson, I don't think you understand. This pool is for the benefit of the entire community. We've already hired the contractors, approved the budget. The access path through your land is the only viable option. Any other route would cost us an additional $60,000. "That sounds like a you problem, not a me problem," I said, straightening up. "I'm sorry you've got this situation, but my answer is no. You don't have permission to cross my land." Her face flushed red, starting at her neck and creeping upward like a thermometer measuring her rising anger. "This is incredibly selfish. We're talking about families, children who deserve a place to swim during the summer. And you're going to stand there and deny them that." "I'm going to stand here and protect my property rights," I corrected. "You should have verified access before approving your construction plans." Patricia straightened her shoulders, clutching her papers tighter. "You'll be hearing from our attorney. I can promise you that." She turned on her heel and marched back to her silver Mercedes SUV, leaving me standing in the doorway wondering what I'd just gotten myself into. I'd moved to Colorado Springs specifically for the peaceful mountain views and the independence of living on my own terms. My 2-acre property sat on the edge of the Meadowbrook Estates development, technically outside the subdivision boundaries. The previous owner had been smart enough to keep it separate when the development went in, and I'd been smart enough to verify that before purchasing. I went back inside and pulled out my property documents, spreading them across my kitchen table. The deed was crystal clear. My lot, officially designated as Parcel 847B, had never been part of the Meadowbrook Estates subdivision. It predated the development by 20 years. I'd done my homework when I bought the place, specifically because I'd heard horror stories about HOAs from friends and family. My phone rang an hour later. "Unknown number. Mr. Anderson." A man's voice, professional, clipped. "This is Robert Chen from Morrison and Associates. I represent the Meadowbrook Estates HOA. I understand there was an incident this morning regarding property access." "There was no incident," I said calmly. "Your client showed up uninvited and made a request. I declined. That's how property rights work. Mr. Anderson, I'd like to invite you to a mediation session. Perhaps we can reach an arrangement that benefits everyone involved." The HOA is prepared to offer compensation for the easement. "How much compensation? We're thinking $500 would be fair. I almost laughed. $500 for permanent access across my land. Access that would bring constant traffic, noise, and liability issues. No thanks. What would you consider fair? Chen asked, his tone shifting slightly. Nothing, I said. There's no amount of money that would make me agree to this. I value my privacy and my property rights. Find another route for your pool access. There was a pause. Mr. Anderson, I should inform you that if this matter isn't resolved amicably, the HOA is prepared to pursue legal action. There are provisions under Colorado law regarding necessary access to landlocked improvements. Your pool isn't landlocked, I countered. It's being built within your subdivision. You have roads, you have access points. You just don't want to spend the extra money to use them. That's not my problem, and it's not grounds for forcing an easement. Chen's voice hardened. You'll be receiving formal documentation shortly. I'd suggest you retain legal counsel. The line went dead. I sat back in my chair, staring at my phone. This was escalating faster than I'd expected. I'd dealt with difficult people before during my years working construction management in Denver, but this was different. This was someone trying to force their way onto my property through legal threats. I called my real estate attorney, Marcus Webb, who I'd worked with during the property purchase. He listened to the situation without interrupting, then let out a long sigh. Andrew, you're legally in the right here, Marcus said. Your property is separate from the HOA and they have no authority to demand access. However, they can file a lawsuit claiming prescriptive easement or necessity. It'll be expensive to defend, even though you'll likely win. How expensive? Could be anywhere from $10,000 to $30,000 in legal fees, depending on how far they push it. I felt my jaw clench. So even though I'm right, I have to pay thousands just to prove it. Welcome to the American legal system, Marcus said dryly. Look, let me draft a formal letter establishing your position. Maybe that'll make them think twice. Sometimes these HOA boards are run by people who get drunk on power, but when they realize they're risking the association's funds on a losing case, they back down. And if they don't, then we fight it, and we make sure they pay our legal fees when we win. 3 days later, a process server showed up at my door with a lawsuit. The Meadowbrook Estates HOA was suing me for $50,000 in damages, claiming that my refusal to grant access had caused delays and additional costs to their construction project. They were also seeking a court order for a mandatory easement across my property. I called Marcus immediately. They're bluffing, he said after I read him the complaint. This is a pressure tactic. They're hoping you'll see the lawsuit and cave. File our response, assert your rights, and let's take this to court. I'll also file a motion to dismiss based on lack of merit. Over the next 2 weeks, my peaceful life turned into a legal nightmare. Patricia Whitmore proved to be relentless. She started a social media campaign on the neighborhood Facebook group, painting me as a cruel, selfish person who was denying children the joy of having a community pool. She conveniently left out the part where I wasn't part of their community and had no obligation to help them. The posts got nasty fast. Andrew Anderson is a disgrace to our neighborhood, one post read. He's holding our children hostage over his greed. Shame on him. Another. I heard Anderson is demanding $100,000 for access. Who does he think he is? I didn't even have a Facebook account, but friends started sending me screenshots. The lies were spreading faster than I could counter them. Marcus advised me not to engage, saying anything I posted could potentially be used against me in court. But Patricia wasn't done. She organized a protest. On a sunny Thursday morning, about 30 people showed up at the end of my driveway with signs. Access for all, one read. Stop property bullying, said another. The best one was Anderson Hates Children, which was both false and hilariously over the top. I watched from my living room window as the protesters marched back and forth, chanting slogans. A local news van pulled up and I groaned. This was turning into a circus. My phone rang. It was Marcus. "Don't talk to the press," he said immediately. "I'm serious, Andrew, not a word. Let me handle any media inquiries." "Too late to leave town for a few weeks?" I asked. "Unfortunately, yes. Just sit tight." This kind of theater usually burns itself out, but it didn't burn out. That evening, the local news ran a story titled "Property Dispute Divides Colorado Springs Community." They interviewed Patricia, who dabbed at her eyes with a tissue while talking about disappointed children. They showed the protesters. They mentioned the lawsuit. They didn't interview me, despite calling 3 times. Marcus had intercepted each call and politely declined on my behalf. My neighbor to the west, an older man named George Hartley who'd lived in the area for 40 years, called me that night. "Andrew, I saw the news," he said. "Don't let them push you around. I remember when they tried to incorporate your property into the HOA 15 years ago. The original owner fought them off. This is the same power grab, just a different excuse." "You remember that?" I asked. "Hell yes, I remember. They wanted to build a tennis court back then, needed access through his land. He told them where they could stick their tennis rackets. Eventually, they built it somewhere else, cost them more money, and life went on. Patricia's husband was on the board back then too, same entitled attitude. This information was gold. George, would you be willing to testify about that if this goes to court?" "Absolutely. I've got documents too." The previous owner gave me copies of everything when he sold, said I might need them someday if the HOA ever started causing trouble again. I thanked George and immediately called Marcus with this new information. He was thrilled. "This establishes a pattern of behavior," Marcus said. "It shows the HOA has a history of trying to force access through your property for their convenience. This is great for our case." The preliminary hearing was scheduled for 6 weeks out. In the meantime, life became increasingly unpleasant. Someone kept leaving passive-aggressive notes on my truck. "Nice vehicle for someone who doesn't care about kids," one said. Another read, "Hope you enjoy your blood money." The harassment escalated when someone threw eggs at my house. Then my mailbox got knocked over. I installed security cameras and filed a police report, but without clear evidence of who was responsible, there wasn't much the Colorado Springs Police Department could do. "Probably kids from the neighborhood," the officer said, taking my statement. "Heard about your situation on the news." People get worked up. "So I'm just supposed to deal with vandalism because of a legal property dispute?" The officer shrugged sympathetically. "Keep documenting everything. If it escalates or you catch someone on camera, we can press charges." Patricia's campaign continued online. She posted daily updates about the cruel neighbor blocking pool access and the suffering families who just wanted a place to swim. The local newspaper ran an opinion piece about property rights versus community benefit, which at least presented both sides. But the damage to my reputation was ongoing. I went to the grocery store and got dirty looks from people I'd never met. Someone actually cursed at me in the checkout line, calling me a selfish jerk. I stopped going to my usual coffee shop after the barista gave me attitude about my order. This was insane. All because I'd exercised my legal right to control access to my own property. Marcus filed our response to the lawsuit, along with a counterclaim for harassment and legal fees. He also submitted George's testimony and documents from the previous access dispute. The HOA's attorney, Chen, responded with a motion to exclude George's testimony as irrelevant. The weeks crawled by. I threw myself into work, managing a commercial construction project in downtown Denver, grateful for the distraction. But every evening, I came home to my besieged property, checking my security cameras for new vandalism and avoiding eye contact with anyone who might recognize me. Then things took a darker turn. I was working in my garage one Saturday afternoon, about a week before the hearing, when I heard shouting from my driveway. I walked out to find Patricia Whitmore standing there with a surveyor and two large men in work clothes. "What's going on?" I demanded. Patricia looked at me with cold satisfaction. "We've obtained an emergency easement order. These gentlemen are surveying the access route for immediate construction." "You've obtained what?" I pulled out my phone and called Marcus. "Mr. Anderson, you need to step aside," one of the workers said. "We have legal authorization to be here." "Nobody has authorization to be on my property," I said, keeping my voice level while Marcus's phone rang. The surveyor, a thin man with a clipboard, looked uncomfortable. "Sir, we were provided documentation by the HOA's attorney. We're just doing our job," Marcus answered. "What's happening?" I explained quickly. Marcus was silent for a moment, then his voice came back sharp and angry. "Put Patricia on the phone, now." I held out my phone. "My attorney wants to talk to you." Patricia took it with a smug smile, but that smile faded as Marcus spoke. I couldn't hear his words, but I could hear his tone, professional steel cutting through whatever nonsense she'd been told. But our attorney said. Patricia started. She listened more. "I don't appreciate your more listening." Her face went pale. "Fine. We're leaving." She shoved my phone back at me and gestured sharply to the surveyor and workers. "Pack it up. Apparently there's been a miscommunication." "What kind of miscommunication?" I asked, taking my phone back. "Andrew, you still there?" Marcus's voice came through. "Yeah, I'm here." "They forged an emergency order. Or rather, they lied to a judge about the nature of the dispute to get a temporary access order. I've already filed a motion to vacate it and reported their attorney to the state bar." "This is serious misconduct." I watched Patricia and her crew load back into their vehicles, the surveyor shaking his head and arguing with her about something. The two workers just looked confused. "Marcus, they just tried to illegally access my property with fake legal documents." "I know. And this is going to torpedo their entire case. Judge Morrison does not appreciate being lied to. I'm requesting an emergency hearing." The emergency hearing happened 3 days later. I sat in the courtroom next to Marcus, watching as Patricia Whitmore, her husband Gerald, and 2 other HOA board members sat with Robert Chen at the opposing table. Chen looked distinctly unhappy, which gave me a small measure of satisfaction. Judge Elizabeth Morrison entered, and we all stood. She was a woman in her 60s with sharp eyes and an expression that suggested she'd seen every kind of legal shenanigans imaginable and had no patience for any of it. "Let's get straight to the point," Judge Morrison said once we were seated. "Mr. Chen, explain to me how your client obtained an emergency access order without notifying opposing counsel." Chen stood, smoothing his tie. "Your Honor, there was a misunderstanding about the proper procedures. My client was informed by a clerk that—" "Stop," Judge Morrison interrupted. "I've reviewed the application for the emergency order. It claims that Mr. Anderson's property is landlocked, that there's no other access route, and that immediate access was necessary to prevent health and safety issues. None of these claims appear to be true based on the actual complaint. Did you verify these facts before submitting the application?" "Your Honor, my client provided me with information that—" "Did you verify the facts, Counselor? Yes or no?" Chen's jaw tightened. "I relied on my client's representation, which means no." Judge Morrison turned her attention to Patricia. "Mrs. Whitmore, stand up please." Patricia stood, her confidence from my driveway completely gone. "Did you tell your attorney that Mr. Anderson's property was the only possible access route to your proposed pool location?" Judge Morrison asked. "Well, it's the most cost-effective." Patricia started. "That's not what I asked. Is it the only possible route?" Patricia's face flushed. "No, but the alternative would cost significantly more. So you lied in a legal filing to save money." Judge Morrison's voice could have cut glass. "Mrs. Whitmore, do you understand that obtaining a court order through false pretenses is a serious matter? Do you understand that you could face criminal charges for this?" The courtroom went silent. Patricia's face went from red to white. "I didn't think. Our attorney said it was just a formality." "Your attorney said nothing of the sort, or if he did, he should be disbarred." Judge Morrison looked back at Chen. "Mr. Chen, I'm referring this matter to the State Bar for investigation. You are an officer of this court, and you have a duty to verify the information in your filings." "This is unacceptable." She turned to Marcus. "Mr. Webb, I'm vacating the emergency order immediately. I'm also inclined to dismiss the underlying case with prejudice, but I'll give Mr. Chen one opportunity to show me why I shouldn't." Chen stood again. "Your Honor, while the emergency order was improperly obtained, the underlying dispute about property access is still valid. The HOA has invested significant resources into this pool project based on the understanding that access could be negotiated." "Based on the understanding," Judge Morrison repeated. "Not based on any legal right, not based on any easement, not based on any agreement with Mr. Anderson. Based on an assumption. Your client's poor planning does not create an obligation for Mr. Anderson to surrender his property rights. We're requesting the court consider the public benefit of the pool facility," Chen tried. "The public," Judge Morrison said. "This is a private HOA amenity for a private community that Mr. Anderson is not part of. There is no public benefit argument here. Try again." Chen looked at his notes, clearly struggling. "Colorado law allows for easements by necessity when property is landlocked or there's no other reasonable access," Judge Morrison finished. "Neither applies here. The pool is being built within the HOA's existing property boundaries. You have access through your own roads and property. You just don't want to spend the money to use that access. That's not necessity, that's convenience." Marcus stood. "Your Honor, if I may, we're also asking the court to award attorney fees and to order the HOA to cease their harassment campaign against my client." "Harassment campaign?" Judge Morrison looked interested. Marcus pulled out a thick folder. "We've documented over 40 social media posts by Mrs. Whitmore and other HOA board members defaming my client, false statements to media outlets, organized protests on his property, and multiple acts of vandalism. We have police reports, security camera footage, and witness statements." He walked the folder up to the bench. Judge Morrison flipped through it, her expression growing darker with each page. "Mrs. Whitmore, did you organize protests at Mr. Anderson's property?" she asked. Patricia stood again, her voice defensive. "It was a peaceful demonstration. We have First Amendment rights." "On his private driveway, that's not a public forum, that's trespassing." Judge Morrison looked at the documents again. "These social media posts are defamatory. You've accused Mr. Anderson of extortion, of hating children, of various other false claims. You've posted his personal information online." "I was just keeping the community informed," Patricia said. "You were engaged in a targeted harassment campaign to pressure him into giving up his legal rights," Judge Morrison corrected. "That's not protected speech. That's tortious conduct." She closed the folder with a sharp snap. "Here's my ruling. The underlying lawsuit is dismissed with prejudice. The Meadowbrook Estates HOA is prohibited from filing any further actions related to access across Mr. Anderson's property. Mrs. Whitmore and all HOA board members are ordered to cease and desist all social media posts, public statements, and any other communications regarding Mr. Anderson and this dispute. They are to post a retraction and apology on the same platforms where they posted defamatory content. Patricia started to object, but Judge Morrison held up a hand. I'm not finished. Mr. Anderson is awarded his full attorney fees and costs, to be paid by the HOA within 60 days. Additionally, I'm ordering the HOA to pay $10,000 in sanctions for the fraudulent emergency order. That money will go directly to Mr. Anderson as compensation for the harassment he's endured. She looked directly at Patricia. Mrs. Whitmore, I'm strongly considering referring this matter to the district attorney for criminal charges related to the fraudulent court order. The only reason I'm not doing so immediately is because I want to give the DA's office time to review the facts independently. But make no mistake, you could be facing criminal prosecution. The gavel came down with a sharp crack. This hearing is adjourned. I sat there stunned. It was over. Not only was it over, but I'd won completely. Marcus was grinning beside me, gathering his papers. Behind us, Patricia was arguing in harsh whispers with her husband and the other board members. Chen was packing his briefcase quickly, clearly wanting to get away from his clients as fast as possible. We stood and headed for the exit. As we passed the HOA's table, Gerald Whitmore grabbed Patricia's arm. Do you have any idea what this is going to cost us? The HOA's insurance doesn't cover sanctions for fraud. How was I supposed to know the judge would? Patricia hissed back. You lied to a judge, Patricia. What did you think would happen? Outside the courtroom, Marcus shook my hand. That went better than I could have hoped. Judge Morrison doesn't mess around with misconduct. What happens now? I asked. Now we collect. I'll file the fee documentation, which will be substantial given how much time this took. The sanctions are immediate, and the HOA has to figure out how to build their pool without your property, which is their problem, not yours. And the criminal charges she mentioned. Marcus's expression turned serious. That's up to the DA. Fraudulently obtaining a court order is a crime, but it's not always prosecuted. Given that it's an HOA dispute and no one was physically harmed, they might decide it's not worth their resources. But it'll hang over Patricia's head for a while, which might make her think twice about this kind of behavior in the future. We walked to the parking lot together. The Colorado afternoon sun was bright and warm, and for the first time in months, I felt like I could breathe. Go home, relax, and let me handle the rest, Marcus said. I'll send over the fee documentation for your review in a few days. After that, we just wait for them to pay up. I drove home, half expecting to find another protest or some new form of harassment, but my driveway was empty. The security cameras showed no activity. I went inside, grabbed a beer from the fridge and sat on my back deck, looking out at the mountain views that had convinced me to buy this property in the first place. My phone buzzed with a text from George Hartley. Heard you won in court. Congratulations. Those busybodies finally got what they deserved. I smiled and typed back a thank you. Over the next few days, something remarkable happened. The social media posts disappeared. Patricia posted a terse, legally worded apology that clearly came from an attorney, stating that she had made false statements about me and regretted any harm caused. The neighborhood Facebook group suddenly had several members posting in my defense, pointing out that I'd been right all along to protect my property rights. I even got an apology from the barista at my coffee shop. I'm sorry I was rude to you, she said, looking genuinely embarrassed. I only heard one side of the story. I didn't realize what was really going on. It's fine, I told her. That's how these things work. The loudest voice isn't always telling the truth. 2 weeks after the hearing, Marcus called with an update. The HOA's insurance company has informed them that they won't cover the sanctions or attorney fees because they resulted from intentional misconduct, he said. Patricia and the other board members are being held personally liable. There's talk of them being removed from the board. How much are we talking total? I asked. Between my fees, the sanctions, and the other costs, about $45,000. The board is having an emergency meeting tonight. According to my sources, there's a petition to recall the entire board and elect new leadership. Wow. It gets better. The DA's office contacted me. They're opening an investigation into the fraudulent court order. They want to interview you as a witness. I sat down. They're actually pressing charges. Looks like it. The DA I spoke with said they're taking it seriously because it undermines the integrity of the judicial system. If people can lie to judges without consequences, it opens the door to all kinds of abuse. The interview with the DA's office happened a week later. I met with Assistant District Attorney Rebecca Torres at the El Paso County Courthouse. She was a no-nonsense woman in her 40s who recorded everything and asked detailed questions about the timeline of events. Walk me through what happened when Mrs. Whitmore showed up at your property with the surveyor and workers, she said. I explained the confrontation, the fake emergency order, and how my attorney had exposed it as fraudulent. And at any point, did Mrs. Whitmore or anyone from the HOA try to properly negotiate access with you? Torres asked. They offered me $500 early on, but when I declined, they went straight to legal threats and public harassment. There was never a good faith negotiation. Torres made notes. The thing that concerns me most is the pattern of escalation. It started with demands, moved to lawsuits, then to public defamation, and finally to using the courts fraudulently to force access to your property. That shows a willingness to abuse legal processes for personal gain. So you think there's a case? I think there's a strong case for obtaining a court order under false pretenses, which is a Class 6 felony in Colorado. I'll be presenting it to my supervisor, and if they agree, we'll file charges. A month later, formal criminal charges were filed against Patricia Whitmore and Robert Chen for attempting to obtain a court order through false statements. The news made the local papers again, but this time the coverage was very different. Headlines read, HOA president faces criminal charges in property dispute, and attorney charged with court fraud. The story detailed how Patricia had lied to obtain the emergency access order and how Chen had failed to verify the information before submitting it to the court. Public opinion, which had been so firmly against me, swung completely in the other direction. I received apologetic emails from neighbors I'd never met. One woman wrote, I signed the petition against you and I'm so ashamed. I should have gotten the facts before jumping on the bandwagon. Thank you for standing up for property rights. The Meadowbrook Estates HOA held an emergency election. Patricia and the entire board were recalled. New leadership took over, and one of their first actions was to send me a formal letter of apology and a check for the full amount of attorney fees, costs, and sanctions ordered by the court. The new board president, a software engineer named David Martinez, even called me personally. Mr. Anderson, I want to apologize for everything you went through. The previous board acted recklessly and illegally. We've reviewed the pool plans and found an alternative access route that stays entirely within HOA property. It'll cost more, but that's our responsibility, not yours. We should never have involved you in this. I appreciate that, I said, surprised by his reasonableness. We're also implementing new policies to prevent this kind of abuse of power in the future, David continued. Financial transparency, term limits, and a requirement that any legal action over $5,000 requires a full membership vote, not just board approval. That sounds like good governance, I said. It's the least we can do. Again, I'm very sorry for what happened. If you ever need anything from us, please don't hesitate to reach out. The criminal case moved forward slowly, as court cases tend to do. Robert Chen accepted a plea deal that involved surrendering his law license, paying a fine, and performing community service. His legal career was over. Patricia fought the charges initially, claiming she'd been given bad legal advice and hadn't understood the implications of the emergency order application. But the evidence was clear. She'd signed a document stating under oath that my property was the only access route and that there was an immediate health and safety necessity. Both statements were provably false. Her attorney, a different one this time, eventually negotiated a plea deal. Patricia pled guilty to one count of attempt to obtain a court order under false pretenses, a reduced charge from the original felony. She received 3 years of probation, 200 hours of community service, and a permanent record. More importantly, she was permanently banned from serving on any HOA board in Colorado. I attended the sentencing hearing. The judge, a different one from our civil case, was blunt in his assessment. Mrs. Whitmore, you abused the legal system because you didn't want to spend extra money on your HOA's pet project. You defamed an innocent man, harassed him, and then committed fraud against the court itself. The only reason you're not going to jail is because you have no prior record and you've accepted responsibility through your plea. But make no mistake, this conviction will follow you for the rest of your life. Patricia stood there, her perfect composure finally cracked, tears running down her face. Her husband sat in the gallery, looking exhausted and angry. After the hearing, I ran into Gerald Whitmore in the parking lot. He approached me hesitantly. "Mr. Anderson, I want you to know I never supported any of this," he said. "Patricia wouldn't listen to me. She got obsessed with that pool project, convinced herself she was doing the right thing for the community. She could have just built it a different way," I said. "I know." I tried to tell her that, but once she got pushback, it became personal for her. She couldn't stand the idea of anyone telling her no. He shook his head. "This whole thing has cost us our savings, our reputation, and now she has a criminal record. All because she couldn't accept that someone else had rights that mattered more than her convenience." I didn't know what to say to that, so I just nodded. "For what it's worth, I'm sorry," Gerald said, then walked away. Life slowly returned to normal. The Meadowbrook Estates, HOA, completed their pool using the alternative access route. It opened that summer to no fanfare, just families quietly enjoying their amenity the way it should have been from the beginning. I stopped getting dirty looks at the grocery store. My security cameras showed nothing but the occasional deer wandering through my property. The harassment had completely stopped. Marcus closed out the case officially, and I paid his final bill from the money the HOA had been ordered to pay me. I actually came out ahead financially, though that had never been the point. One evening, about 6 months after Judge Morrison's ruling, I was sitting on my back deck with a beer, watching the sunset paint the mountains purple and gold, when George Hartley walked over from his property. "Got a minute?" he asked. "Always. Want a beer?" "Don't mind if I do." I grabbed him one from inside, and we sat in companionable silence for a while, watching the light fade. "You know what you did was important, right?" George finally said. "I just protected my property," I said. "You did more than that. You showed people that HOAs don't have unlimited power, that individual rights still matter, and that bullies don't always win. He took a sip of his beer. When I was dealing with them 15 years ago, I sometimes wanted to just give in, let them have their easement and stop the harassment. But I knew if I did, they'd just keep doing it to other people. The previous owner of my property, I said. You mean him? Yeah, Frank Morrison. Good man. Passed away a few years back, which is why the property went up for sale. He'd be proud of how you handled this. Morrison, I said. Like Judge Morrison, George grinned. His daughter. I might have made a few phone calls when your case was assigned. Wanted to make sure you had a fair hearing. You sneaky old man. Just looking out for the neighborhood, George said. The real neighborhood, not the HOA's version of it. We clinked bottles and watched the stars come out. The following spring, I was working in my garden when a car pulled up my driveway. I tensed for a moment, old reflexes from the harassment days, but it was just David Martinez from the HOA. Mr. Anderson, sorry to drop by unannounced, he said, getting out of his car. I wanted to give you this in person. He handed me an envelope. Inside was a check for $3,000. What's this for? I asked. The old board had used HOA funds improperly for their legal campaign against you. We've been auditing the finances and recovering money where we can. This is your share of the recovered funds, based on the proportion of harassment and legal action directed at you versus the costs to the association. I stared at the check. I wasn't expecting this. You shouldn't have needed to expect it. The previous board broke the rules in multiple ways. We're trying to make things right. David hesitated. Also, I wanted to invite you to our summer barbecue. I know you're not part of the HOA, but we'd like to extend an olive branch. No pressure, no expectations. Just an invitation to be neighborly. I thought about it. The old me, the one who'd been through months of harassment, would have declined immediately. But the wounds had healed, and David and the new board had proven themselves reasonable. I'll think about it, I said. Thanks for the invitation. That's all I can ask, David said, shaking my hand before leaving. I went back inside and deposited the check, bringing my total financial gain from the whole ordeal to something substantial. But more valuable than the money was the principle I'd defended and the peace I'd reclaimed. My property was still mine, on my terms with my rules. The mountains still provided their stunning views. The deer still wandered through my garden, and I could sit on my deck each evening without wondering what fresh harassment tomorrow would bring. I thought about Patricia sometimes, wondering if she'd learned anything from the experience or if she just felt victimized by the consequences of her own actions. I thought about Robert Chen, whose career had ended because he'd chosen convenience over ethics. And I thought about all the people who joined the mob against me based on lies and manipulation, who'd been so quick to judge without knowing the facts. But mostly, I just enjoyed my property and my peace. A few weeks later, I decided to attend the HOA barbecue. It felt like the right move, a way to close the chapter completely. The event was held at the newly completed pool area, and I had to admit, they'd done a nice job with it. The alternative access route worked perfectly fine, and the pool itself was attractive and well-maintained. People were friendly but a little awkward around me at first, not quite sure what to say. But as the afternoon wore on and the beer flowed, conversations became easier. Several people apologized for believing the lies about me. Others thanked me for standing up to the old board's corruption. A teenage girl approached me near the food table. "Are you Mr. Anderson?" she asked. "I am." "I'm Sarah Martinez. My dad is the new HOA president. I just wanted to say thank you." "For what?" "For showing me that it's okay to stand up for what's right, even when everyone is against you." We studied your case in my civics class. My teacher used it as an example of how property rights work and why the legal system has checks and balances. I was genuinely touched. That's nice to hear. I hope you learned something useful. I learned that doing the right thing isn't always easy, but it's always worth it, she said, then smiled and went back to her friends. As the sun set over the pool party, I realized that the whole nightmare experience had been worth it, not for the money or the victory, but for the principle. I'd protected something important, not just for myself, but for everyone who valued individual rights over collective convenience. I stayed at the party until the end, helping David and some other neighbors clean up. As I walked back to my property that evening, I felt something I hadn't felt in a long time, a sense of community. Not the forced, rules-driven community of an HOA, but the organic kind that comes from people choosing to be good neighbors to each other. My phone rang the next morning. It was Marcus. "Andrew, I wanted to give you a heads up. The Colorado Bar Association published a summary of the Chen case in their monthly bulletin. They're using it as a cautionary tale for attorneys about due diligence and ethical responsibilities." "Is that common?" I asked. "When the misconduct is this egregious, yes. They want to make sure other attorneys don't make the same mistakes." He paused. "There's also been some interest from legal journals about writing up the whole case. They're calling it a landmark example of HOA overreach and the importance of property rights. Would you be willing to be interviewed? Will it help other people in similar situations?" I asked. "Absolutely. HOA abuse is a growing problem across the country. Your case provides a clear roadmap for how to fight back legally and effectively." "Then yes, I'm willing." Over the next few months, I did several interviews for legal publications and property rights organizations. The story spread beyond Colorado, picked up by national news outlets as an example of HOA dysfunction and the importance of defending individual rights. I started getting emails from people across the country who were fighting their own battles with overreaching HOAs. I couldn't offer legal advice, but I could offer encouragement and share the lessons I'd learned. Document everything, hire a good attorney early, don't engage in public arguments, and stand firm on your rights. One email particularly stood out. It was from a woman in Arizona whose HOA was trying to force her to remove solar panels from her roof, despite state law protecting her right to have them. She'd been fighting for months and was ready to give up. "Your story gave me hope," she wrote. "I've hired an attorney and I'm going to see this through. Thank you for showing that it's possible to win against these bullies." 6 months later, she emailed again to tell me she'd won her case. The HOA had backed down when threatened with legal action, and her solar panels remained on her roof. That email, more than anything else, made the whole ordeal feel worthwhile. My fight hadn't just protected my property. It had inspired others to stand up for their rights too. A year after Judge Morrison's ruling, I was sitting on my deck on a Saturday morning, coffee in hand, when a familiar silver Mercedes pulled up my driveway. For a moment, my stomach clenched, old instincts kicking in. But the car stopped at a respectful distance, and the person who got out wasn't Patricia. It was Gerald Whitmore. I stood up and walked to the deck railing. "Can I help you, Mr. Anderson? I know I'm probably the last person you want to see," Gerald called up. "But I was hoping I could talk to you for just a minute." I considered sending him away, but curiosity won. "All right, come on up." He climbed the deck stairs slowly, looking older than I remembered. The stress of the past year had clearly taken its toll. "I won't take much of your time," he said. "I just wanted you to know that Patricia and I are getting divorced. It'll be final next month." I didn't know what to say to that. "I'm sorry." "Don't be. It's been coming for a long time. This situation just made it clear we wanted different things out of life. He looked out at the mountain view. She's moving to Phoenix to live with her sister, starting over, trying to put this behind her. And you? I asked. I'm staying here. This is my home. I'm not going to let her mistakes drive me away from a place I love. He turned back to me. I wanted to apologize one more time, personally, not as her husband, but as someone who should have stopped her and didn't. I knew what she was doing was wrong. I should have put my foot down harder. You tried, I said, remembering the arguments I'd overheard in court. Not hard enough. And I'm sorry for that. He held out his hand. I hope one day you can forgive us, both of us. I shook his hand. I already have. Holding on to anger doesn't help anyone. Gerald nodded, looking relieved. Thank you. That means more than you know. He started to leave, then turned back. By the way, that pool everyone was so worked up about. Half the families never use it. Turns out the demand wasn't as high as Patricia thought. All that trouble for something that sits empty most days. He laughed bitterly and walked back to his car. I watched him drive away, feeling a strange mix of emotions. The whole situation had been so pointless. If Patricia had just accepted my initial no and found an alternative route from the beginning, none of this would have happened. No lawsuits, no harassment, no criminal charges, no destroyed reputations or broken marriages. All because someone couldn't accept that their convenience wasn't more important than someone else's rights. Life continued peacefully after that. The seasons changed, winter snow giving way to spring flowers, summer heat yielding to autumn colors. My property remained my sanctuary, a place of peace and privacy that I'd successfully defended. I never joined the Meadowbrook Estates HOA, though my relationship with the community improved significantly. David Martinez and I became friendly, occasionally grabbing coffee or helping each other with property maintenance. I attended a few more HOA events, always as a guest, always making it clear I was there as a neighbor, not a member. The new board ran things responsibly, without the power trips and overreach that had characterized Patricia's leadership. They focused on maintaining common areas, organizing community events, and staying out of people's personal business. The way an HOA should operate. 2 years after the lawsuit, I was interviewed for a documentary about property rights in America. The filmmakers wanted to include my case as a centerpiece example of HOA overreach and the legal remedies available to homeowners. During the interview, they asked me what I'd learned from the experience. I learned that rights aren't just abstract concepts in legal documents, I said. They're real things that have to be actively defended. If we don't stand up for our rights, they disappear. Not all at once, but gradually, as people get used to having them eroded. Do you think it was worth the stress and expense of fighting? The interviewer asked. Absolutely. Because it wasn't just about my property. It was about the principle that individuals have rights that even a majority can't vote away. That's fundamental to how our society is supposed to work. The documentary aired on PBS the following year and was well received. I got more emails from people fighting their own HOA battles, and several lawyers contacted me asking to use my case in their presentations on property law. I never sought out the attention or the status as a property rights advocate. I'd just been a guy trying to protect his land and his peace. But if my experience helped others, I was glad to share it. 3 years after Judge Morrison's ruling, I was working in my garage when George Hartley walked over with a bottle of bourbon. "Anniversary gift," he said with a grin. "Anniversary of what?" 3 years ago today, you told Patricia Whitmore to shove her pool access where the sun doesn't shine. Figuratively speaking. I laughed. You've been keeping track. Damn right. It's a day worth celebrating. You did what Frank Morrison did, what I've tried to do. You protected this land from people who think rules and regulations are more important than freedom. We sat on my deck and poured ourselves drinks, toasting the sunset and the mountains and the simple right to be left alone on your own property. "You ever regret buying this place?" George asked. I thought about it, looking out at the view that had sold me on the property 5 years ago. Not for a second. Even with all the trouble, I'd do it again. "That's the right answer," George said, raising his glass. "To property rights, to good neighbors, and to telling busybodies to mind their own business." "I'll drink to that," I said, and we did. The sun set over the Colorado mountains, painting the sky in shades of orange and purple and gold. Somewhere in the Meadowbrook Estates development, families were probably using the pool that had caused so much trouble. But up on my property, outside the HOA's jurisdiction and control, I sat in peace with a good neighbor and a good drink, secure in the knowledge that I defended what mattered. My land was still mine. My rights were still intact, and no HOA board, no matter how determined or powerful they thought they were, had been able to take that away from me. That was worth every moment of stress, every dollar in legal fees, and every ounce of effort I'd put into the fight. Because some things are worth defending, no matter the cost. And property rights, individual freedom, and the rule of law are at the top of that list.